तुम्ही पळयतात प्रुडंट. यू आर वॉचिंग प्रुडंट. तुम्ही पळयतात प्रुडंट. यू आर वॉचिंग प्रुडंट.
नमस्कार येवकार, दिस इज गोवा 360 डिग्री आफ्टरनून शो. एका मोठ्या प्रश्नाक हायकोर्टान हात घाला. 2-3 प्रकरणां अशी हायकोर्टा मुखार आयली which are raising the serious question that too comes from the High Court bench: is Goa lawless? Has Goa become lawless? हो हायकोर्टाचो सरकाराक आणि पोलिसांक प्रश्न. आणि हाजे क्रक्स इतल्यात आसा की वेदर BNS अथवा नवी जी IPC रिप्लेसमेंट आसा, जी नवी व्यवस्था आसा, तातूंत सुद्दां कॉग्निजिबल ऑफेन्सांक FIR रजिस्ट्रेशन कंपल्सरी आसतना कितल्योश्योच केशी अश्यो येतात जे पब्लीक प्रेशराक लागून, पॉलिटिकल प्रेशराक लागून पुलीस FIR रजिस्टर करनात. कायदेशीर सक्ती आसून सुद्दां रजिस्टर करनात. अशी 2-3 प्रकरणां हायकोर्टा मुखार आयली आनी तातूंतल्यान हायकोर्टान हो विचार उक्तायलो, सरळ प्रश्न केलो की इज गोवा लॉलेस. आतां सद्या लेटेस्ट एक प्रकरण चालू आसा, ऑफकोर्स विच इज नॉट रेफर्ड टू बाय हायकोर्ट एज येट. तें Z+ सेक्युरिटीचे मनशाक एअरपोर्टाचेर खंय तरी कार्यकर्ते घेराव घालता BJMचे. पॉलिटिक्स अपार्ट, Z+ सेक्युरिटीचे मनशाक एअरपोर्टाचेर कोण तरी येता आनी घेराव घालता. पोलीस आर सायलंट, सेक्युरिटी इज सायलंट, आणि थंय दोन्ही राजकीय पक्षाचे कार्यकर्त्यां मदीं लॉ अँड ऑर्डर कशें सिच्युएशन तयार जाता. दिस इज अ थर्ड रेफरन्स नॉट येट कोटेड, कारण काँग्रेसीन फॉर्मल कंप्लेन केल्या बिईंग अ Z+ सेक्युरिटी फॉर खरगे देवलो तेन्ना एअरपोर्टाचेर प्रकार हो. सो हाका धरून हायकोर्टाचे ह्या फाटले 1-2 प्रकरणांनी या जंय FIRs वेर डिलेड बिकॉज ऑफ सो कॉल्ड पॉलिटिकल प्रेशर. पयलीं मातशें काँग्रेसीक आयकुया.
द लीडर ऑफ ऑपोजिशन ऑफ राज्यसभा अशें आसतना एक स्टेट गेस्ट आसतना Z+ सेक्युरिटी जाका आसता ताच्या विरुद्ध प्रोटेस्ट करता आनी तांकां ती जागा दिता पुलीस, गोवा पुलीस. हातूंत भितर खंय ना खंय तरी एक कॉन्स्पिरसी आमकां दिसता. गोवा पुलीस हातूंत शामील आशिल्ले काय ना हे आज गोवा पुलिसांनी स्पश्ट करपाक जाय. सगळे जी सेक्शनां आसा जी BNS कायद्या अंडर येता ताच्या अंडर हो क्रायम जाता आनी हाजेर कॉग्निजिबल ऑफेन्स आशिल्ल्या कारणान इमिजिएटली ऑफेन्स रजिस्टर जावपाक जाय आशिल्ले, तें अजून पर्यंत जाल्ले दिसना.
आणि दामू नाईक तू कितें शिकयता तांकां, कितें शिकयता? आणि मुख्यमंत्री प्रमोद सावंत, तुम्ही तरी बाबा समजून घ्या. तुम्ही होम मिनिस्टर, तुम्ही स्टेट गेस्ट, हे लोकांक तुमची इमेज किती जाता ते पळया. तुमची इमेज पुढूक पाड, आमची गोयची इमेज किती जाता ते तरी चिंता मातशें एकदा. अरे एक राष्ट्रीय पक्षाचो अध्यक्ष येता गोंयान आणि त्याचे अशी सिक्युरिटी लॅब्स जातात, ते बी एअरपोर्टा भायरच. तुमची इमेज चिंता, बरे तुमची इमेज गेली खड्ड्यान, तुम्ही गोयची इमेज चिंता कितें जाता ती.
Now let me go to High Court's observations pertaining to couple of recent cases and then move to reporter. High Court कितें म्हणटा पळयात. Has Goa become a lawless is the question posed by High Court. This is to Goa cops. Cognizable offensesanच्या बाबतींत FIR रजिस्टर करप मॅन्डेटरी पुलिसांक, तरी पुलीस कित्याक करनात. प्रायमरी इन्क्वायरी सुद्दां गरजेची आसना इन केस ऑफ कॉग्निजिबल्स. पुलीस डिले कित्याक करतात. हायकोर्ट स्लॅम्स पोंडा पुलीस फॉर डिलेइंग रजिस्ट्रेशन इन FIR इन कपल ऑफ केसीस. एक म्हणजे बोरये साईबाबाच्या देवळांक एक जमाव घुसता, प्रॉपर्टी थेफ्ट करता, कंप्लेन करता टेम्पल ऑथॉरिटीज, FIR जायना. 9 दिसांनी FIR जाता. दुसरें प्रकरण MPAच्या प्रॉपर्टींत छत्रपती शिवाजीचो आतां एक्चुअली तो आयकॉन हरशी पवित्र शिवाजी, पूण ताका कसले कसले प्रकरणांनी त्या आयकॉनाचो नाका थंय यूज जाता आनी डॅमेज जाता ते पळयात. MPAच्या ऑथॉरिटींक वचून एरियेक वचून पुतळो उबारतात. इट्स अ क्लियर केस. MPA म्हणटा आमचे प्रॉपर्टींत ट्रेसपास एनक्रोचमेंट जाला, FIR जायना आनी हायकोर्टात प्रकरण गेलें तरी आतां आउट ऑफ कोर्ट सेटलमेंट करतात, सेईंग क्लेमींग लॉ अँड ऑर्डर सिच्युएशन जातली म्हणून तो पुतळो काडपाक गेल्यार. पुलीस खंय? सरळ ट्रेसपास नॅशनल ऑथॉरिटी सेंट्रल ऑथॉरिटीचे एरियेक, पोर्ट ऑथॉरिटी एरियेक, तांचे पोर्ट एरियेचेर पब्लिकाक डिस्प्यूट आसूं, बट इट्स अ सिरियस केस. FIR कितें? ह्यो 2 केसी घेवन हायकोर्टान बरेच पुलिसांक वडीर काडले की तुमचे BNSच्या अंडर कंपल्सरी मॅन्डेटरी आसून सुद्दां तुमचे FIR कित्याक जायना? प्रिलिमिनरी एन्क्वायरी करप गरजेची ना इन केस ऑफ सच कॉग्निजेबल ऑफेन्सीस. It appeared there was no rule of law and that Goa had become a lawless state. High Court observes. High Court questioned whether there was any rule of law in the state or whether there was complete lawlessness. High Court bench. High Court also referred to another instance of alleged lawlessness in which a group of people installed statue of Chhatrapati in the property of MPA. Cases involving a cognizable offense, concerned police should have registered FIR immediately and that no preliminary inquiry is required in such cases. हा मुकेशाकडे नेता. Mukesh, the prosecution or the police were also made party before the court in these cases. Or in fact, even the prosecution or the government was representing the Home Department or police. What is the explanation from the prosecution on delay in FIRs in a cognizable offense which is mandatory under BNS? What's the explanation?
Yes, this matter pertaining to the Honda Sai Baba temple matter, in which Honda police took almost 9 days to register FIR. This matter came up for the hearing before the High Court for the first time yesterday. And the court has issued notice to the Honda police, means IO, and IO has been directed to come up on the next date of hearing with the case files. But issue was that it was clear case of the petitioner that a group of persons, whatever may be the reason, just trespassed into the temple premises. They unlocked the lock, broken the lock, and they committed theft of CCTV cameras, DVR, and there are some allegations under that. But the prima facie issue is that it is for sure theft was committed or not. There were internal disputes or what was the reason, that is the secondary thing. But the first thing was that a group of persons entered, created ruckus, committed offense as a law. But Honda police took 9 days to register FIR. So High Court was very unhappy with the action, or rather inaction by the Honda police, and asked the question that where there is a rule of law or not, or the state has become lawless state. Because High Court again mentioned this, and I remember last week High Court was hearing the MPA issue, installation of statue of the Shivaji Maharaj. So that day also the High Court had observed that what is this? A mob comes and they do whatever they want to do, and the police remains quiet. They take time to register FIR. Rather, in that MPA case, FIR is not registered till date. Though the Advocate General on behalf of the state contended that that is not a heinous crime, so FIR registration is not required. High Court just remained quiet on the statement made by the Advocate General, but issue was similarly raised. That day also the High Court had asked that it seems that Goa has become a lawless state. In front of mob, police doesn't act. That means once the mob gathers, that means police can't do anything. And similarly, it has been seen in this Honda case. So next date of hearing has been kept on 25th August, and the High Court has directed the investigation officer to come up with the case file, and then IO has to explain that why he took 9 days to register FIR, and what are the progress in the investigation in this matter? So,
मुकेश, आय एम कमिंग टू युअर नेक्स्ट इश्यू. बिफोर मुकेशान सांगला तांचेर तुमकां कळण आसतलें, अंडर IPC आसूं आदलो किंवा BNS, police does not have a discretionary power whether to register FIR or not in case of a cognizable offense. Preliminary inquiry म्हणटा तो प्रकार असल्या गजालींनी नाच. ती Z+ सेक्युरिटी ब्रीच आसूं, MPAचे आसूं, छत्रपतीचो पुतळो आसूं किंवा थेफ्ट ऑफ CCTV इन साईबाबा टेम्पल एंड थेफ्ट ऑफ कॅश, whatever, or theft of property or ransacking or whatever, trespass. There is no explanation. कांयच एक्सप्लेनेशन प्रोसिक्युशन गव्हर्नमेंट किंवा पुलिसा कडल्यान हायकोर्टा मुखार ना. आनी हायकोर्ट सरळ दुसरे केसीक आतां उक्तायता मत की हेज गोवा बिकम लॉलेस. आनी आतां तिसरें प्रकरण येता. ऑफकोर्स दिस इज नॉट कोटेड बाय हायकोर्ट, बट दिस इज अ सिमिलर केस वेर देर इज अ ब्रीच ऑफ सेक्युरिटी. कितें आसूं, पॉलिटिकल ताजे फाटल्यान कितें आसूं, ड्रामेबाजी आसूं, पॉलिटिक्स आसूं, दॅट गोज ऑन. बट प्रिमा फेसी Z+ सेक्युरिटी मनशाची सेक्युरिटी हॅज बीन ब्रीच बाय अ क्राउड or a mob. It leads to a law and order type situation and FIR is not registered. आता दुसरे इश्यू कडेन येता. दिस इज ऑल्सो रिलेटेड टू पुलीस अँड सेक्युरिटी अँड सर्विलान्स. हो इश्यू भिकाऱ्यांचो आनी खासा करून ल्हान भुरग्या भिकाऱ्यांचो. हायकोर्टा मुखार अशें PIL आयला आतां की देर इज अ बिग रॅकेट गोईंग ऑन, अँड दीस इज स्पेशली फ्रॉम पयलीं. एक म्हणजे सॅक्स रॅकेट हें वेगळें, ही जनरली नॉर्थ इस्टाच्यान तेवटेच्यान ह्युमन ट्रॅफिकींग जाता गोंयांत. बट इन केस ऑफ चायल्ड बेगर्स रॅकेट्स, हे नेक्सस जे आसा गोंयांत जे भिकारी भुरगीं दिसतात, दे आर मोस्टली trafficked from Dharashiv, that is Usmanabad in Maharashtra. So High Court मुखार ही केस आयल्या की इंटरस्टेट पुलीस सर्वेलन्स कितें करता. इवन समजा तांकां गोंयांत धरलीं, तांकां अपना घर किंवा जेलींत दवरपा मेळना. ती ल्हान भुरगीं कोणे तरी एबडक्ट करून फसोवन हें करून उखलून हाडिल्लीं आसता, किडनॅप करून, आनी हांगा भिकेक लायिल्लीं आसता. सो तांकां रिपॅट्रिएट करून तांकां थंय परत व्हेलीं किंवा थंयच बाबा तांचो परत पुनर्वसनाचो प्लॅन कितें. ती परत हाडची न्ही म्हणून त्या टोळयांचेर तुमचे कसले एक्शन्स जाता. इंटरस्टेट सर्विलन्साक ह्या टोळयांचेर कोण नजर दवरता. असल्यो येवच्यो न्ही. आयल्यो जाल्यार रिहॅबिलिटेट जावच्यो, रिपॅट्रिएट ती भुरगीं जावची, रिपॅट्रिएट जावची. सो ह्या सगळ्या खातीर हायकोर्टान आतां महाराष्ट्राच्या पार्टीकय तातूंत इनवॉल्व कर म्हणल्या, ऑथॉरिटीज एज पार्टीज, की तुमची व्यवस्था कितें आसा. ह्या भुरग्यांक जे भिकेक लायतात रॅकेट्स हाडून, आनी हे जे मदले दलाल आसता, ह्या रॅकेटांचे चेक्स अँड बॅलन्सीस करपाक तुमची व्यवस्था खंय आसा इज अ बिग क्वेश्चन बिफोर सेक्युरिटी एजन्सीज. हांव परत मुकेशा कडेन वता. मुकेश, what are the flaws that have been brought before the police, or has anybody responded yet from Maharashtra? Because the major source of these trafficked children is found to be in Usmanabad. Earlier Usmanabad, that is now the Dharashiv in Maharashtra. This is a slum area from where the children are usually kidnapped, not just in Goa, it's all over, it happens all over India. So why did High Court think in that way that both the authorities of both the states should be made respondent or parties in this case?
Because High Court is hearing one PIL filed by Advocate Moses Pinto for quite some time, and one incident had come into light in the month of May. Mapsa police had rescued 4 minor boys and girls. One girl was just 3 years old, and they were sent to the care home. And families were before the court. They just appeared that their children are taken away, and they were not even able to communicate. I don't know, in Dharashiv there should be Marathi, but they were not even able to speak in Marathi. I think they were speaking Kannada or which language, I'm not sure. But High Court appointed one amicus curiae to assist in the repatriation of those rescued child. And now those children have been given back to the family. But meanwhile, the fact came up, the amicus story in this matter, and there is one CWC report also, which highlighted that for the last 2 years data when we analyzed, it was found that mostly children who are forced into the beggary in the state of Goa are found at Osmanabad district. And there is one SOP here. When CWC rescue any children indulged in beggary, and after some time, after taking some care, they are repatriated back to their families. So suppose the victim, a minor boy or girl, is from Osmanabad. So there is a standard protocol that here in Goa, the concerned CWC writes to the Osmanabad CWC that so and so children have been sent back. So just keep a monitoring about their well-being and keep a watch. But it has been seen, or rather it has been reported by the CWC and the amicus curiae, that concerned CWC is not taking care of those children, whatever may be the reason, the communication gap, or they are not caring about the intimation given by the Goa authority. So with such children, mostly children are from that particular district. So High Court also felt that it would be better to make the concerned authority a party here. So, secretary concerned, secretary of the competent authority have been made a party in this matter. First time they have been made party. Notice has been given to them, and it is expected the next date of hearing when they will be here. It is the great idea of the High Court that if it is isolated case of one district, why not the competent authority of that district be made a party? That there can be checks and balance. So notice has been issued. Next date of hearing, we are expecting that competent authority will come up and the due direction will be given by the High Court.
So मुकेश सांगता एक गजाल तुमकां कळ्ळें आसतलें की दिस इज अ विशियस सर्कल. हें एक त्रांगडें मोठें, कारण जरी तांकां हांगच्यान रिपेट्रिएट केली, ती खंयच्यान तरी उखलून हाडिल्लीं आसतात एजंटांनी, किंवा तांचे एक एकदां पेरंट्सच, तांच्या सो कॉल्ड पेरंट्स आपल्या परिस्थितीक लागून त्या दलालांक काडून विकतात, आनी ते दलाल तांकां काडून त्या भुरग्यांक मागीर देशभर खंयचे भिकेक लायतात. बॉम्बे किंवा मेट्रो सिटीज किंवा टुरिस्ट डेस्टिनेशन लायक गोवा, जंय ट्युरिस्ट मोठ्या प्रमाणांत येतात, तांचे कडेन पयसो घोळटा, अशा जाग्यांनी तांकां ते व्हरून मागीर भुरग्यांक भिकेक लायतात. सो दीस इज अ नेवर एंडींग विशियस सर्कल. हायकोर्टा मुखार इनफॅक्ट ते मोठें एक आव्हानूच आसा, आनी इट इज नॉट जस्ट दॅट इट इज इंडिपेंडंटली रन बाय सम दलाल्स. ताका पॉलिटिकल वेवस्थेचोय वरद हस्त आसता. कमिंग टू नेक्स्ट रिपोर्ट, दॅट इज कोलवाळेक ड्रग्स, मोबायल ड्रग्स ह्यो गजाली. आतां पयर एका सब जेल असिस्टंट जेलरान आत्महत्या जाल्लें प्रकरण आमी पळयलां. त्या जेलींतल्यान 3-4 स्टेटींनी लायक तेलंगणा, दिल्ली, केरळा मल्टी स्टेट रॅकेट चलयतात, ड्रग्साचे तस्करी चलयतात कोलवाळे जेलींतल्यान एजंट भितर वचून. हेंय पळयलां. आनी ते तुमचो स्टाफ ड्रग्साच्या केसींनी सापडपाचो कसोच बंद जायना. आतां ही गोवा ह्युमन रिसोर्स डेव्हलपमेंट जे आसा कॉर्पोरेशन, ते जे भरती करतात तातूंतली ही एकटी आतां लेडी एम्प्लॉई, लेडी स्टाफ, ते गार्ड, जेल गार्ड, तिकाच धरली काल ड्रग्स वतना. थर्मासाक मुळाक लिपोवन गांजा व्हरताली, 2 थर्मासांनी गांजा. मागीर तिचे बॅरेकाचेर रेड मारली तेन्ना थंय चरसी सापडले, 2 काय 3 ATM कार्डां, 2-3 सिम कार्ड सापडली. म्हणजे कितें प्रकार चल्ला ह्या कोलवाळे जेलीक. मातसो PI आयकुया, मागीर हांव मुकेशा कडेन वता.
सांची आयज कंप्लेंट येयली फ्रॉम जेल सुपरिटेंडंट की एक GHRDCची आशा स्टुडंट म्हणजे ताणें डिटेन केला अलॉंग विथ कॉन्ट्राबँड. आमी आमचो पंचनामा केलो, भितर 236 ग्राम्स ऑफ गांजा आनी 2 ग्राम ऑफ चरस मेळ्ळे, आनी आनीक प्रोहिबिटेड आयटम तिचे कडेन मेळ्ळ्या ते कस्टडीन. सो आमी ऑफेन्स रजिस्टर केला तिचेर. ते आतांच ऑफेन्स रजिस्टर केला, इन्वेस्टिगेशन चालू आहा, वील फायंड आउट. सद्या आतां कोलवाचे म्हणून कळ्ळें, बट एक्झॅक्टली कळना कोलवाचे म्हणून कळना.
सर कितून आसलो ड्रग्स?
तिणी वॉटर बॉटल, स्टीलची वॉटर बॉटल हितून कॉम्प्रेस करून घातलेलो. सो फिस्किंग पॉयंटार तिका धरली आनी
Mukesh, just a query in this case, because this lady now, lady guard Asha Chodankar, she has been in custody of Mapsa police now for local police for almost 24 hours now. Any idea to whom was she delivering those drugs? Because as per the protocols of jail, the lady staff is not allowed to serve or guard the male inmates because they are either criminal under trials or convicted criminals. So whom was she delivering these drugs to? Any idea?
Yes, officially they are saying that investigation is still going on, but what happens, this is not she has been arrested in possession of drugs, but issue is that the main jail staffs are involved. That is the only reason when somebody like this accused is attached with Goa Human Resource Development Corporation. What happens? They are on not regular basis. They are on temporary basis employed at jail. But what happens? They have connivance with the main jail staffs, and that's why this network works. So again, the fact will come up. I'm very unsure because if we see that in recent times we've seen several cases, but there is no head away from the main accused. Like this lady has been arrested. You will see after 10-15 days also that there will not come up accused number 2. That is the modus operandi, and the reason is that the main jail staffs are involved in this case. One chain is broken, they will fix that chain, and that network continues. Inmates are involved, similarly jail staffs are involved, but we will see. For now there is no official version, but again in the past history I have seen that there is no accused number 2 in most of the cases. So yes.
म्हणजे एक गजाल स्पष्ट जाता की करबटूच सापडटा, केन्नाच वयले सापडना. सदांच पुलिसाचे जाण्या हे कोलवाळे आनी ते चलत आसता. कितले फाटी कोर्टान रेडी मारपा लायल्यो, कोर्टा हायकोर्टाक रिपोर्ट गेले, आयजी प्रिजन्साक रिव्यू सिस्टम बसोवपा लायली, पूण थंय सर्वेलन्सूय बसयनात, थंय CCTV बसयनात, थंय जॅमरूय बसयनात. सगळें करूं येता पूण कोणाची तें करपाची थंय इत्सा ना. म्हणजे सगळे वेवस्थेक हाताक धरून वयल्यान तें चल्लां अशें मानपाक पूर्ण वाव आसा. आय एम कमिंग टू युअर नेक्स्ट स्टोरी मुकेश, दॅट इज रिगार्डिंग तेजपाल. तरुण तेजपाल हे 2013तले प्रकरण, रेपाचें प्रकरण. आपल्या सहकारी एम्प्लॉई जर्नलिस्टाचे जी ताचे चलयेचे एजीची ताजेर रेप केलो म्हणून ताका निमाणे हायकोर्टान कन्विक्ट केलो. ट्रायल कोर्टान ताका सोडिल्लो, हायकोर्टान कन्विक्ट केलो आनी ताका 10 वर्सांची ख्यास्त मारली. आतां ख्यास्त मारतगीर तो सुप्रीम कोर्टान वता, कारण ताका सरेंडर जावपाक, ख्यास्त भोगपाक 4 सप्तक दिल्यात. त्या 4 सप्तकांत तो आतां सुप्रीम कोर्टाक वचपाचो, चॅलेंज करपाक हायकोर्टाचे वर्दीक. पूण तितले मजगती आतां गोवा हायकोर्ट सुप्रीम कोर्टान गेला सेईंग की ताजी ख्यास्त जी आसा ताका 10 वर्सां न्ही, ताका लायफर पडपा जाय, ताका जल्म पडपा जाय. गोंय सरकार सुप्रीम कोर्टाक आतां गेला. मुकेश कनेक्ट जाता. मुकेश, this seems like almost a caveat by Goa government, where on one side Tejpal is moving before the Supreme Court, first to interim stay the sentence and quash the conviction, and other side government is also moving to seek a lifer instead of 10 years. It almost seems like a caveat. Any development?
Yes, sir. So High Court had passed order on 6th of August convicting Tejpal, and that time only Goa government, one side Tejpal said that he will challenge this order before the Supreme Court because he feels that there is no evidence against him. On the other side, Goa government had that very day said that they will also approach the Supreme Court pleading to enhance the sentence because they feel that offense was very heinous, crime was very heinous, and Tejpal raped the victim girl who was in his authority. She was working under him. So this is a heinous crime. So sentence should be maximum that is life sentence. So on those line only, Goa government has filed SLP, and in which SLP Goa government has prayed for the enhancement of sentence. But what I feel that when the Tarun Tejpal will file his SLP, both matters will be clubbed and the Supreme Court will hear both the matters together, because both will be the connected matters. But for now, Goa government has taken the step to file SLP before the
Mukesh, coming to the trial court's observation, when they rejected his conviction, the plea for his conviction, they said the crime almost has not happened, and the victim itself herself was being quizzed like an accused, the lady victim. Now, while reversing that verdict of trial court, High Court said that no, the crime has been committed, and it's on record through mail communication of Tejpal to that victim that he has committed, and he is seeking apology for that act. So to that extent, High Court said yes, the crime has been committed and he has been sentenced. But coming to that heinous part, or the rarest of rare part, where the court's the conviction leads to a lifer or a capital punishment, that part seems has not been endorsed by the High Court in this case, the heinous or the rarest of rare part. So how strong is the government's case before the Supreme Court as far as this rarest of rare or heinous part is concerned? Because you had listened to those arguments when it was under the High Court also.
See, as I said, that government feels that this is a heinous crime and Tejpal should be given 14 years rigorous imprisonment, because government is saying that he raped a victim girl who was working under him. Means he was having control over that victim girl, and that is the part when law explains that there is one ground where accused or convict can be given the maximum punishment. But when High Court had convicted Tarun Tejpal made submission before the High Court about his age, that he is now senior citizen and there is no record of criminal past, so lenient view should be taken by the court. So High Court considered the lenient view of that part, that he is 62 years old and there is no criminal past, he has been 2 years past. So on those basis, High Court took the lenient view. But again, Supreme Court is a different authority and they can evaluate the things differently, independently. So we can see that both the parties, even Tarun Tejpal and the state of Goa, both have their equal opportunity before the Supreme Court to present their cases. And Supreme Court will not.
So the crux of matter is High Court has reversed the trial court verdict, but considering his age part, and to that extent a linear sentence has been ordered. Thanks Mukesh. इतल्याचेर हो आफ्टरनून शो आमी हांगा सोंपयतात. कीप वॉचिंग. थँक्स फॉर वॉचिंग. देव बरें करूं.